नमस्ते फ्रेंड, आप सभी का स्वागत है। फ्रेंड्स, बैंक पेंशन अपडेशन के संबंध में रिट पिटीशन 41327 ऑफ 2018 ऑफ द ऑनरेबल हाई कोर्ट इन Kerala. Sri C. Golul Raj from Kerala has written a letter to Chief Justice of India, Sri Chandrachud. Most respected Chief Justice, I am an octogenarian, age 82, in the evening of my life. Sri C. Golul Raj ex-service ex-bankers हैं जो 82 years old हैं. I am writing to you in the light of the statement by your lordship and the companion Judge Sri M.R. Shah in Civil Appeal 10186 of 2018, Bhupinder Singh versus Unitech Limited, that the court is under an obligation to undo the wrong done to a party by the act of the court by invoking the maxim actus curiae nimium gravity. With due respect, the judiciary, I regret to inform you that the verdict delivered on 16 August 22 by the Honorable Judge of the High Court of Kerala in my writ petition 41327 of 2080 was not clear-cut. The verdict was indefinite and the inexplicit, couched as an advisory, giving much elbow room to the respondent to finally decide the issue without even giving me a chance to appeal. It was the most unkindest cut of all. All my time, money, hopes and expectations were wasted on a fruitless litigation. I would not have told this if the court had decided the issue instead of leaving the decision to the respondent. My writ petition was against the persistent refusal of Union Bank of India to revise, update my pension in breach of the extant provisions of the pension regulations. Though on the basis of the undisputed facts, the Honorable Judge found that there is every justification for pension to be updated. The petition was disposed of through a common judgment for WPC 29890 of 2018 at WPC 41327 of 2018, advising the petitioners to give a representation to the respondent bank along with the direction to the respondent bank to consider it with a holistic view, sense and the constructive interpretation of any of the provisions and dispose the representation within 2 months. Alas, instead of taking a holistic view within the confines of the judgment dated 16 August 22, the respondent bank took a hostile view and turned down my representation by sitting in judgment on the writ petition. Friends, the magnificent advisory of Honorable Justice Sri V.G. Arun turned out to the self-defeating without giving my right to appeal to. Thanks to the peculiar judgment, the petitioner in WPC 29890 of 2018 and WPC 41327 of 2018 are back to square one after more than 4 years of the impatient wait, making them begin litigation once again from the beginning. The following flaws were conspicuous in the order delivered by Honorable Justice Sri V.G. Arun 4 months after the reversing it for the judgment. First, the judgment dated 16/8/22 was inconsistent with the judgment dated 5th August 22 in writ petition number 11306 of 2015, Abhilash Kumar and others versus Kerala Books and Publication Society of and others, and connected cases of the same judge where it was held that the respondent cannot wriggle out from its liability to pay pension by pleading paucity of the funds. Second, in WPC 11306 of 2015, it was held that pension is a payable notwithstanding non-availability of funds, whereas in my petition, the respondent bank was not directed to update the pension when it had abundant money of employees and retired employees in the pension fund exclusively for paying pension. Third, the Honorable Judge has overlooked the fact pension in Reserve Bank of India having been revised with effect from 1st March 2019. Similar updating of pension by the respondent bank from 1st March 2019 was inevitable as in terms of settlement on pension dated 29th October 93 between Indian Bank Association and Union of Employees entered into pursuant to the Industrial Dispute Act 1947. The pension scheme in the respondent bank has to be exactly similar to the pension scheme in Reserve Bank of India so far as relating to amount of pension, updating, general condition, etc. Fourth, though the counsel of the petitioner put forth the impact of Regulation 35(1) of the pension regulation, this a basic pension and additional pension wherever applicable shall be updated as per formula given in Appendix 1. The judge kept a studied silence on it. Fifth, the judgment was not taking care of impact of Regulation 56 on the pension regulation. In case of doubt in the matter of application of these regulations, regard may be had to the corresponding provisions of Central Civil Pension Rules 1972 or Central Civil Services Computation of Pension Rules 1981 applicable for the central government employees with such expectation and modification as the bank with the previous sanction of the central government may from time to time. Expectation rendering it clear that for making any of the provisions of Central Civil Pension Scheme inapplicable to the pensioners of the respondent bank, it has to determine such provisions with the previous sanction of the central government and notify them in the Gazette of India. Thus, the order dated 16/8/22 was not categorical, directing the responding bank that it shall update the pension simultaneously with the implementation of bipartite settlement, just in the same way Central Civil Pension gets updated with the implementation of each pay commission. In order that reasonable expectation of the litigation do not get veiled, I humbly request that the Honorable Supreme Court may, by invoking the cardinal principle that it is obligatory on the part of courts to undo the wrongs done, be pleased to direct the Honorable High Court of Kerala to recall the order dated 16th August 18 and to issue a fresh categorical verdict expeditiously keeping justice and the fairness uppermost. Alternatively, I respectfully request the Honorable Supreme Court as under. Sri M.K. Ravindran, the petitioner in the writ petition 29890 of 2018, has filed a second writ petition number WPC W42216 of 2022, claiming the same relief which he had claimed in the earlier petition. Considering the genesis of the new writ petition, which is directly attributable to the lack of clear-cut verdict from the Kerala High Court, the Supreme Court may, as a special case, direct the High Court of Kerala to take up the dispose of the writ petition 42216 of 22 expeditiously on a priority basis, as the High Court has already heard the respondents and the only things to be looked into are the fresh arguments of the respondent bank in their speaking order rejecting the representation submitted by the petitioner in accordance with the direction of the High Court. The new continuous of the respondents are listed and rebutted in Annex 1 to this letter. I am requesting this because of a clear verdict on this petition will go a long way to settle my grievance as well. With respectful regards, yours faithfully. फ्रेंड, एक्स बैंकर ने जो पेंशन अपडेशन के बारे में जो वर्डिक्ट आया था केरला हाई कोर्ट से, उसके बारे में अपनी ग्रीवांस से रिक्वेस्ट किया है सीजीआई से, ताकि उसको सेटल करने में उनकी मदद करें। फ्रेंड्स, इसका डिटेल मैं आपको लिंक दूंगा। उस लिंक से आप पूरे कोर्ट के जजमेंट के बारे में अथवा जो लेटर का कॉपी है उसको आप स्टडी कर सकते हैं और देख सकते हैं। थैंक यू फ्रेंड्स, नमस्कार।